Good evening. My name is Joe Stranowski, Chair of the Rockport Planning Board, and we have a quorum this evening, so I'm officially calling this meeting to order at 5:33 on September 22nd, 2022. The Planning Board is comprised of volunteers appointed at the discretion of the Select Board. Our charge is to ensure that the applications that come before us comply with the town's land use ordinance and the Rockport Comprehensive Plan. The board must determine whether there is sufficient evidence in the record, which is the material supplied by the applicant, to support a decision to approve the application. This is accomplished by comparing that information in the record to the ordinance or statute requirements. This evening I would like to seat an alternate, John Veman, as a full voting member. So John will be joining us. Let's see, Orion, I think you have loaded, there were some public comments received. You loaded those up onto the Planning Board SharePoint drive.
Those were uploaded on the SharePoint, and they were uploaded on the town website too.
Okay, thank you. Let's see. We don't need to monitor a live stream this evening since we've got some internet problems here at the Opera House. Okay, so let's move on. So for this evening's meeting, we have one continuance that we'll be reviewing tonight, in addition to some administrative board business after that. Continuance is consideration of a final application site plan review for construction of a cell tower for U.S. Cellular located at Vinyl Street in Rockport and identified as map 17 lot 49-001 within the 908 zoning district. The property is owned by Kathleen Bailey and it's leased to Maine RSA number 1 Incorporated and is being represented by Bob Gashan of KJK Wireless. So with that, why don't you, if you would please step up to the table. So the continuance, last time the board did not vote on this, but did ask for six pieces of additional information. I'll wait till you get seated.
Mr. Chairman, for the record, my name is Kenneth Kazera. I am the principal of KJK Wireless.
Okay.
Bob is here for support.
Okay.
But I'll be your main point of contact this evening.
Welcome.
Thank you. So on September the 6th, Mr. Gashland submitted various documents that had been, my understanding, had been requested by the board. Mm-hmm. And I'd like to just run through those briefly. Then I can answer any questions you folks have. We can go back and circle on to some of the previous things that can be submitted, that had been submitted, and dig in depth wherever you folks would like. Okay? So, Bob submitted, as requested, photos from the nearest property line, location of the facilities, proposed fence line, using a blue tarp as a reference point, and I believe, Ryan, can you display those?
I can, yeah. But before we really dive into that, do you need to seat John?
I did.
Okay, good. I was outside.
Yeah, you were
I just
outside.
wanted to double check.
I did.
So 922, was that the photo report?
Yep. That's one. Okay, so what this shows you is the location of the compound, the location of the property line. Thank you for zooming in. And where photos 1 through 4 were taken. Bob erected a blue tarp where the fence line should be for the 50 by 50 compound, and then traversed to the property line and took the photos that are supplied. Photo 1, as you can see, as has been represented, it's heavily wooded through there, and the blue tarp was not visible. The blue tarp is just under 200 feet from this location.
Approximately how large is that tarp in size? Is it like a 10 by 16 kind of thing?
The tarp was, I hung it 8 feet tall because that's what the fence is going to be.
Okay.
And I got a pretty large size tarp. It was the biggest one I could find was 30 feet.
So it's 30 feet long horizontally. Okay, thank you.
Thanks, Bob. Okay, so we can go to picture 2. And you can see here, very similar view, heavily wooded, and the tarp is not visible.
You ready to move on?
Yes, please, thank you. And here's 3. While we represent that the tarp is not visible, there's a small corner of it that can actually be seen if you look real, real close.
Right.
So you have to know what you're looking for. And then the last one, photo 4, as you can see, there's nothing visible there either.
Okay.
And these are all hardwoods that we're looking through.
I believe there's majority is deciduous hardwood and a small amount of,
Yeah,
Pines?
you're right, most of them right through there were hardwoods.
Yeah, let me just say on photo 4, there's a tiny, tiny bit of blue available, visible also. If you look very close, there is.
okay. Mr. Gashlin also provided you folks with photos and a description of the proposed driveway access point at Vinyl Street as requested.
Get to it. From Vinyl Street Road.
And what we have here first is a roadway detail, which is the typical driveway section that we prepare on the hundreds of facilities like this that we have built. And then the next one shows the
Excuse me,
guardrails.
right there on that photo, I assume the break in the rail is where the driveway would go in?
Yes,
Okay.
correct. And you'll see there are guardrails to both the north and the south there. And if we need to adjust those for the entrance to make our turns, we will. And I believe that the opening there is approximately 16 feet wide. So it's pretty close to what we need, so any modifications will be minor in nature.
How significant is the drop-off there from the road to? I think
Well-
in the road plan, you said you'll meet the 4% grade.
Yep.
I'm just curious about this. It looks like it drops off considerably from the.
Well, we're going to have to bring some fill in there to actually achieve that 4% grade, but
Sure.
it's possible.
Yeah, thank you.
Yep.
Okay, which one are you going to next?
Well, we're going to wait a minute, I think, because
Yeah.
Ryan will be back momentarily. There it is. So we want to look at the calculated radio frequency exposure report. It's the first item.
This one here?
Yep. Thank you. Okay, so this calculated RF exposure report prepared by C Squared Systems, who is our outside consultant on all matters RF. We can cut to the chase towards the end, and it will give you a summary, which if I can borrow that.
Yes, sure. Excuse me.
Yep.
Realizing that most of the people here on the board are not communications engineers.
Sure.
It might be beneficial for you just to simply, from lay terms, just kind of walk through the calculation and what the limit is. I think that would be beneficial.
Okay. So the calculation is based on power density and the ERP, which is the affected radiated power. That's the amount of power that comes out from the antennas. And you can see the formula there with the radial distance, horizontal distance from the antennas, vertical distance. And those numbers are all plugged in by C Squared. And then they produce number 4, which is the calculation results. So you'll see that our antennas at 145 feet, our operating frequency, which is 700 megahertz. We're having one transmitter, and that ERP that I talked about a minute ago, the effective radiated power is 1,770 watts, and the power density is 0.052 with a limit of 0.4667, and it produces what is the MPE percentage of 1.10%. Now, the MPE percentage is established by the FCC, and the best way to explain it is it's like a credit limit. So we could technically, under the FCC guidelines, go up to 100% MPE and still be compliant. This facility will produce power equal to 1.10. So very small amount. And obviously, these numbers are measured at the antennas, which are 145 feet in the air.
At 1.1%, any other carriers who may attach to this in the future, would there be any outside possibility you would breach the 100%?
No.
Thank you.
Nope. The only place you may see 100% is when you're on a building rooftop where there's multiple carriers.
Okay, thank you.
Okay?
A building rooftop that would be at the same elevation as the antenna,
Yes,
145 feet in the air.
sure.
So when.
No, but I mean not a building rooftop out here. I mean, let's say on
Yes.
the roof of this building, if there
Correct.
were antennas,
Right.
if they're all placed together, because it's a small geographical area.
John?
Well, just to follow up on Mark's question, so other providers can jump on this tower at some point in the future?
A requirement of your ordinance, we are required to allow our competitors to locate on the facility, yes, sir.
So would we be expecting to see essentially the same numbers for every additional?
You'd see a very similar number. Everyone uses slightly different frequencies because we're all licensed slightly different from the FCC. But even if we put 3 or 4 carriers on there, you're not going to get anywhere above 10%.
And then in there, I think it's this report, if I'm not mistaken, is there a map showing the direction of the flow?
There shouldn't be from this report.
Okay, maybe it's another report.
You're
go
thinking
ahead
of
and
the RF report with the coverage maps?
Yes, that one. Attachment C, it's US Cellular antenna data sheets and electrical patterns.
One of the last pages in that one.
Oh, okay.
This one?
Is this what you're
That's it.
referring to, sir?
Right there, it's on the screen.
Okay, yep. So that is, every antenna that's produced has a radiation pattern. And the best way to describe it is the signal comes out of the antenna and it's like a flashlight. It travels straight for a distance and then travels towards the ground. So that shows you that it is what is known as a 65-degree bandwidth antenna. There'll be 3 of those located on the tower at 145 feet. And those provide essentially 360 degrees of coverage into our coverage area from the facility.
So this is the projection in any one direction?
Yes.
Okay.
Yep.
It looks like that is the vertical beam width. Is that correct, the way I read that graph on the right-hand side?
I got to get out my readers, sorry.
I think it is. Because it says on the left that the vertical beam width is about 9.1
Yeah,
degrees.
and the horizontal is the 65 degrees
Right,
that I mentioned.
and so it
Yep.
looks like 9.1 degrees for the main lobe there.
Yep.
Is that correct?
Yep.
Okay, so could you just explain, so this is looking from the top of the tower, and this is the way the energy is directed out of the antenna.
Yep.
Could you maybe go up to the screen there and point as to where structures on adjoining abutting properties might be in that beam width, like where they would, what kind of power they would see? I mean, I guess I'm asking, are abutters going to be at the 0-degree angle here and be in the maximum power?
The power is its maximum at the antenna itself. That's why
Right.
I give the flashlight
Right.
analogy. If I shine a flashlight, it's going to be bright to you folks, but by the time it gets to the corner, it's not going to be able to light up anything. And it's the same thing. So, Brian, would you by chance be able to pull up our site plans on here?
Each concentric ring, does that represent a distance?
Do you want me to pull up the
I
site
want
plan?
to show them what I mean on the.
That was on.
Original submission.
Mark, my understanding with those kinds of graphs is that the distance is sort of unitless, like it doesn't really matter.
Yeah.
You could shrink it or enlarge it, it's still
Okay.
gonna be the same
Yeah,
graph.
okay, understood. Thank you.
I'm gonna guess there it's actually in dB, because it has -10, -20, -30. So it's probably gain of the antenna, is probably what it is. The
But it would be the
concentric rings.
same graph if you were to double all those numbers?
Yep, it's all relative, yeah.
Yeah.
Is there another one that was the site plan?
We
I think so.
Oh, I'm sorry.
The actual site plan.
The site plan would be separate from,
That's
from
what I was
that,
getting
because
at,
it's
yeah.
such a large
I think the house is down here.
New site plan, here we go. It's loading.
Here we go. Keep going for me. So it's 4 or 5 pages. Keep going. I'll stop you if you're.
Okay.
Stop. Okay, so here is the panel antennas located on the mount on the tower and the directionality of those antennas. Okay, and as you can see, each antenna has what's called an azimuth, so the direction that it provides the coverage to. And it provides the signal out at 145 feet so that it can travel out, in most cases, 1.5 miles, 2 miles, sometimes 2.5. Okay. So it's not, these antennas are not aimed at the ground. They're aimed, they typically have a small amount of down tilt to them, which it says here electrical down tilt of 2 degrees, but they're not aimed so that they are going to be aiming at any structures nearby. That's not the purpose of the facility. It's a macro facility to cover a large geographical area. So the signal will travel out, like I mentioned, approximately 2.5 miles.
Okay. Is there a picture in here of the tower, a side view of the tower?
Yeah, there's an elevation if you scroll up. One more, I think. Yeah, there it is.
Okay. So that data from the antenna said that you had a 9-degree vertical azimuth. So if you were to show with your finger there, where would that main lobe, that 9 degrees, be going out? What direction? It would be going out that way?
Yep, straight.
Okay.
Yep.
Okay, and so we've got a structure that is, I don't know, 200-300 feet away, and so that would be below that main lobe?
Now you're getting into an area that I don't have a level of expertise to be able to answer that question.
If that's 150, 145, it's just a right triangle, right?
Okay. All right, thank you. That answers some of those questions.
And this would be.
So just to summarize on the RF exposure report, it shows compliance, and we meet the burden of proof set by the FCC and the Telecommunications Act of 1996. And then the fourth item was a cost estimate to remove the facility provided by Mr. Gashlin of approximately $45,600.
The question, sort of put this in context of how one might understand a cell tower. Is this cell tower markedly different than one that would be in an urban environment where abutters would be much closer, there'd be more of them, and the cause for concern would be greater?
In an urban environment, things are dramatically different because you have far more obstacles than we do here, where the biggest issue for our facility is hills, valleys, and leaves and pine needles on trees. Whereas in an urban environment, you've got other structures that are either similar in height or near the height of the facility. So, many times in urban environments, you put the antennas significantly lower because that's all the structure that you have to be able to use. So,
But the same quantifying of
you're trying to cover
power.
a smaller geographical area in an urban environment,
Mhm.
so you're not radiating as much power.
Okay. And it'd be more tower is assumed.
Correct, they'd be,
A smaller
they'd be closer together.
Right.
Any questions on the removal cost?
Am I looking at the right document? Didn't this say the town of Warren in it? Am
I think that was submitted as an example.
Yeah, that was the
last time.
example.
okay, so we've got one that actually
Yes.
refers to
Yeah,
the
and it's
right
updated, it's a different amount, I believe it's more to remove this one.
Okay.
You've got the correct one.
What, did that have an exact amount in the first submission? Did that have an exact amount of that surety bond, or did it just say estimated?
I'm starting to lose track of which documents we're looking at, because there's
The example that you submitted for removal
of the original 722.
application.
this is the,
The removal,
Yes, the original one, not the.
Yeah, that surety bond, did that have an amount in it?
the example that we submitted with our original application was at the town of Warren, and that was for $64,000.
yeah,
And the only difference between that bond and this estimate is Warren's ordinance required like a 25% increase in the estimated cost.
Right, so we produced the 46,000, multiply it by 25%, get the new total.
Okay, thank you.
Mr. Chairman, can I circle back on a couple of things that we submitted previously, or do you have
Were
questions
those,
for me?
okay, so there were 6 items that were requested in the continuous last time. And let me just read off what those 6 items were. View the property line of a butter to south using blue tarp at base of site location. You covered that. I'm sorry, there were 6 items, but all were not for you. 2 were for us. There was a breakdown of the surety bond. You provided that. There was images of the entrance from Vinyl Street. You provided that. And a copy of the rights of easements. I didn't see that in the package.
I have that for you,
Okay.
Mr. Chairman. If I may, point out that here on the second page, I'll grab my glasses so I can read it to you. It states that also conveying an easement in common with others for ingress, egress, and utilities from the easterly side of the Vinyl Road over the 50-foot right-of-way depicted on said plan. And
Okay.
it has a plan attached,
Mhm.
which the plan is also shown on our site. And we've
yep.
also had the surveyors
Mhm.
lay out the easement. So we are using the easement for exactly what it is
Mhm.
said to, ingress, egress, and utilities.
Okay.
So we're not overburdening the easement in any way, shape, or form.
Thanks. Okay, warranty deed. Okay, so for the board, the document that I have just been handed, as the applicant stated, it does have a phrase in here, which again I will repeat. What we had asked about last time was the rights of this applicant to use that easement, because it's right on the property line, the way it's depicted, and it's 50% on the adjacent property, 50% on this property. And so the statement that was just pointed out here, I'll read it again, states in the warranty deed for Kathleen Solomon Bailey, okay, it says, also conveying an easement in common with others for ingress, egress, and utilities from the easterly side of Vinyl Road over the 50-foot wide right-of-way depicted on said plan. And so on the original plot that we received last time, it did depict where that easement road was proposed. Let's see.
And we only utilize a portion of the easement for our access.
And then it just further goes on to state that reference is made to a plan entitled Boundary Survey for Marion E. Salmonen, 300 Vinyl Road, Rockport, prepared by Richard Cranston and Chapman, dated May 2006. So it appears from the deed here that there are rights to be able to gain access to the property as requested. So I will leave this with Orion that you could scan that in, or you get a copy?
I got a
to
copy.
scan? Okay. As a part of our public record. Okay, so that satisfies the last remaining one that I had. So we've got two items that we had on our plate, the planning board, but I'll let you go ahead and finish before we start into our luck.
Okay, well, if there's anything I can assist you with, we can certainly talk about those now, and then I can just run through the original application materials so that we have a kind of circle the wagons back up.
Okay. Does the board feel at this time that we need to go back through the initial application, or does everyone feel that they're comfortable with that, what was submitted?
I'm pretty comfortable with that.
Yeah, I'm
Okay.
comfortable with it.
Pretty thorough.
Okay.
Yep.
Thank you for that offer. Okay, so that if you have nothing else to say, sir, in your opening comments, then we will deliberate on the updates that we've got in the application here. So let me just address the board. Typically, this is a continuance, and so in the initial hearing of this application, we allowed a section for public comment and opened it up for public comment. And this is a continuance, and we've gone through and passed through that ground as a matter of process. And so it would come to a question for the board whether we would want to allow, again, in the continuance, an opportunity for public comment. Anybody have any thoughts or opinions on that?
I think it should be allowed.
Given there's new material, I think that there's
Okay.
reason for public to comment.
Fair?
Yep.
Okay, all right. So typically what we do in order then is after the applicant presents an overview before the board deliberates, what we would do then is open up the proceedings here for public comments. And so is there anyone in the room that would care to offer any comments? And if so, please step up to the podium. Introduce yourself and then please state your concerns or comments.
I'm Annie Kiermeyer. I'm an abutter to this property. Orion, do you have the letter that I sent to the planning board 2 days ago that you could put up? And I believe I sent a while ago to all of you. You had a link to an article on major health concerns. To say it very quickly, Lucy and I would plead with you to please move this tower further away from our house. We are very, very scared about health concerns. There are myriad health concerns that have been found since that 1996 federal law. And so I know that in some ways your hands are tied, so to speak, but that's the initial letter. That's not the one I sent 2 days ago.
Okay, I got another one up here. There's that
That's the one I sent in March.
And
Anyway, so if you've had a chance to review that letter, it states exactly what I'm saying right now, which is we would like very much, we're really quite scared for ourselves, for future owners, and for the more future towers that are going to be going up in Rockport and around the world, quite frankly. I really feel that this is like the DDT issue of the 21st century. And I think all of our healths are at risk, but in particular right now our health is at risk.
Okay. So if I could just ask, that 1,500 feet that you stated, is that based on some scientific
That's
fact
based on some of the information from the health article that I submitted to all of you. There are varying forms of research that have been done using various standards of distances from cell phone towers for homes and for schools. But the one most frequently that I read about was approximately 1,500 feet. Anyways, as far away as it can get from our house, it would be better, especially hearing what he just said a few minutes ago, which is that we have a higher frequency here because you have, in urban areas, you have towers that are more closely placed and therefore there's less radiation. So we're going to be getting more radiation than somebody in an urban area would be getting. And I don't know why, when they began all this, they didn't think about the location of our home. Anyways, we're very scared, and we would plead for your help.
Okay, thank you for your comments.
Thank you.
Mr. Chairman, may I correct something for the record?
Sure.
There is definitely more radiated power in an urban environment than there is in a rural environment because of all the facilities. There is also no standard for any kind of 1,500 foot setback. I've been doing this for 25 years and done it all over the Northeast and never seen any kind of setback of that type.
Okay, thank you. Yes, please step up.
My name is Lucy Bauer, and I'm also with Annie, owner of the abutting property. I would submit to you, as indeed our lawyer, Beth Beppel, did in her letter submitted, that the standards of the ordinance have not been met in two regards. One is that those wonderful those photographs of the from the edge of the property to the place where the cell phone tower will be, all of that buffer is on land that these folks don't control. They don't lease that land. They lease only a small amount where the tower is. So that's a bit deceptive in the fact that they don't control it. It's a mature area, so I would, mature mixed deciduous hardwood forest, but I would just submit that that doesn't meet the standards that you have in your ordinance for really having a site plan. Are they going to replant when those trees go, or whatever? What plan do they have, and what overland that in fact they don't control? And the other is that excuse me, having a mental the road that place where the road is going is held in common, those between Kathleen, between the owner of the land who is leasing her part to it, but the 50-foot, that's only 25 feet, that's hers. The other 25 feet is owned by the abutter and was passed to that parcel of land when Marion Salmon split it. So I don't know what happens there, but you're dealing with only one of the owners of that right-of-way. So that I just point that out to you. So that's not exactly meeting. I mean, that needs further work, or that's not meeting the standard. Forgive me, I'm being a little
No, it's okay. Take
verbose.
your time. Take your time.
So anyway, those were just the two things I wanted to point out that I would think you would want to, I would suggest that you may want to look at in relation to the standards of your meeting the standards of the ordinance.
Okay,
That's all.
If I may just clarify one thing. So it sounds like your concern is about the potential removal of the trees that are between your property and where this would be right.
I'm just, I mean, what plan do they have?
Okay.
They're counting on something that isn't under their control. That's all I'm
Okay, but I just want to understand, your concern is about the removal of the trees. Your concern is not about the way that it's screened today with the existing trees in there, it sounds like.
I'm only concerned, what my concern is about presenting a supposed plan which includes land that isn't leased, and therefore over which they have no control. It's an easily remediable thing, situation I would, imagine. But I just point that out. So if the trees were to fall, what would happen? Or, if they were clear cut, because they could be, whose responsibility is that? So it just is, they don't control that, whatever,
Understand.
that's all.
Okay, thank you.
Yeah, thank you.
Thanks.
And also, I should say, the major concern for me as well is health. I'm very well aware that the Federal Communications Act of 1996 was long before people had a long experience with cell phone towers. That was in the relative infancy of cell phones. So anyway,
Okay,
Thank
thank
you.
you. Thanks. Anyone else for public comment? Okay, then I'll close the public comments section of this proceeding, and we'll enter into board deliberation now. And so before we get started here with that, I'd just like to call your attention, and I know all the board members have seen the correspondence from our town legal counsel. And we asked for counsel in two specific areas. One was we asked last time, I know some board members were concerned about whether the coverage that is described here could be met with existing antennas. And connected with that, it was asked if the board has the authority to ask for a third party to take a look at whether that coverage can be provided with existing antennas or towers that are in the town. And again, that's a provision in the ordinance. It does state that the board needs to have demonstrated to it clearly that existing facilities cannot satisfy the current need. Okay, so that was the first one. And the second one was regarding this board and the town's ability to make judgments with respect to the safety and placement related to RF emissions. And so the attorney did also respond on that one, and those were the two items. So now let's talk just a little bit about the responses that we did receive. So first off, with respect to the FCC rulings, and I believe that is, I don't know, Article 47, U.S. Code, Section 332 of the FCC. There is a section in there, Section 7, Item B, that talks about preservation of local zoning authority and talks about the limitations of the local municipal zoning authority. And our attorney has referenced this and steered us towards this, and I'd like to just read what that clause does say in that statute that I cited. It states, no state or local government or instrumentality thereof may regulate placement, construction, and modification of personal wireless service facilities on the basis of the environmental effects of radio frequency emissions to the extent that such facilities comply with the Commission's regulations concerning such emissions. Everybody got that one? Understand that one? Okay. And then the second one, or actually the first one I stated, the ability of the board to request a third party to take a look at this and see if this requirement can be satisfied with existing facilities. Yes, we do. And that's the opinion of our town council, that if the board felt uncomfortable with the data that was presented to us, that we could ask for a third party review of that to determine if these requirements could be met in a different way with existing facilities. So those are the two opinions we got back from our attorney, and we will just go through those and consider those now in our deliberations. So, where to start? Why don't we go through, I would propose the 6 items here that we had on the continuance. Let's start with that, and then as a matter of process, we'll go back through. We did not approve any of these. We reviewed sections, but we did not vote and approve that this application was compliant with the requirements of the land use ordinance. So after we complete our discussion of these items, then I would propose we go back through and consider the land use ordinance and whether or not we consider the application compliant with it. Okay, so that's what we'll do as a matter of process here. So the 6 items we had, copy of rights of easements. Let's start with that one. And so that regards this, this easement, the road that goes up the side of the property with the easement. Is there a chance for Orion that we could bring up the map that shows, I think it was from the original submission, that shows the plot and where that easement is going up along the property line? I think it's that one.
Plan?
Yes, let's see.
That's a butters list. Oh, there you go. Right there. Oop, I think that'll, well, let's go down one more. Right there.
The, Mr. Chairman, the one previous shows the entire easement, a lot easier to see it than.
Yeah, that one is complicated. Let's look at that, and could you blow that up a little bit so we could see that, that property line there and the road and the notes that go along with it?
Talking about this?
No, go ahead down. That, yeah. So the note says existing 50-foot wide easement, okay, and there is on the right-hand side there, it does say property line is the line, dashed line in the middle there. Okay, so the way this depicts it, and this is, what's that saying on the upper right-hand side, that Marion Salomon, what's a,
If I may, Mr. Chairman, I can help you out.
I'm just trying to find the source of this information, what that is, that document.
This is
This.
this is the plan attached to the back of the easement.
Okay.
That is referenced.
Okay, so it's part of the deed.
Yep.
Okay. Okay, and indeed it is. It's the same thing. Okay, thank you. So that's the source. So this is the deed we're looking at. So please go back up again. So this is showing on the deed that the, I'm sorry, back to the road. This is showing on the deed that the road traverses the property line. It appears that it's 50% on one side of the property and 50% on the other side of the property. And based on the document that was presented here, which again is the deed, it says that this easement is conveyed for ingress, egress, utilities, and it's along that property line there. So the question we have before us is that easement allowed to be used for the purpose of accessing this property?
I would just have the main question I would have there. The main question I would have there would be the interpretation of an easement in common with others. What does that mean?
I'm not an attorney, but I would interpret that as in common, meaning it would be in common with that property owner and either of those parties could use it. Is that a correct interpretation, Mr. Planning Development Director?
That's a correct interpretation. It's in the deed for it. So it's kind of hard. In other words, the only way to undo it is to have the deed updated and this to be removed.
But it means either party
Either party
could use it,
could use it.
either property owner.
That's correct.
So just so I'm totally clear, easement in common means either party can use it for their own purposes.
That's correct. So if the other party wanted to access it and go up, they could go up.
Understood. Okay, thank you.
Other questions on easement? Okay, not gonna make this a formal vote, but just as a straw vote, does everyone agree with a show of hands that the easement would be accessible for the uses intended? Straw vote? Yes?
Yeah.
Yes. John? Yes. Okay. Okay, so let's move on to the next item. view from property line of a butter to the south using blue tarp at base of site. Okay, so we looked at those photos, and in those photos, in the summertime with a lot of vegetation, in 2 of those photos, we could just see a little bit of that blue tarp coming through from the property line. We requested that last time just to understand how much it could be viewed. And I guess just to introduce the topic here, in my mind, if there was another structure built there, if there was a house built there, I think in the 908 you could build a commercial property structure there. If there was another structure there, you would see that structure likely from the property line also. And so it wouldn't be a tower necessarily, but it would be a structure. So it's not unheard of that on a piece of property you could see another structure from a property line. There were some questions, though, that were brought up here about whether a landscape plan was presented and required.
My understanding was we requested those photo evidences as a means of not having them produce a landscape plan. That was my understanding.
Oh, okay.
Because the landscape plan is intending to show the landscaping that would screen the base of the tower through the use of plants, and the screening of the base of the tower is the reason for the photos. So I thought that they'd be one and the same.
In the site plan application, it references page C1.
References a bunch of pages, actually.
That was just an aerial
specifically,
photograph,
aerial photograph of the red.
which I think we took issue with as a landscape
Right.
plan.
I guess I don't recall the
Landscaping.
blue tarp pictures to be a replacement for that. But perhaps I don't have a great memory, so I don't recall that.
Okay, so when I looked back through the original application, there were a few things. I did see that reference to C1. I think there was a reference to C4, to G1. And in there, there was a note in G1 or C1 that stated that there were a large number of trees on the wooded property, and it broke them down by percentages of the type of trees, whether they were deciduous or coniferous, and the approximate height of those trees. Okay, so that was included. It's not a classic landscape plan like we would see for a more developed property, but that was referenced as a landscape, part of the landscape plan. The fact that those trees were there. And as you can see in the photo here, it's a fairly heavily wooded area. It didn't state how many trees there were, but it did state sizes and by percentage the types of trees. The only other part referenced in that landscaping plan was a reference to what they call the landscaping plan, was a reference to grass seed that would be planted around the fenced-in area. And the fact that that grass seed would be maintained and would be replanted if necessary. And so as best I could tell in the original submission and the reference to a landscape plan, that was what was included. So again, it's not like a classic landscape plan like we would normally see in a more developed area or an area that was visible from a roadside, but it included some of the elements. And then the other thing it talks about in the landscape plan requirements is that there needs to be discussion of fences and screening, if there is any, that are erected on the property. Other comments on that?
On landscaping?
Yeah, I'd like to.
Well, it's just, it seems to me that we're making a special case of a cell phone tower and some fencing. If you drive down any street, you see a succession of telephone poles and wires. I mean, I don't see anything worse than that. Wires and, public utilities for electricity and telephone, they're all strung along the street. It's unsightly as heck, and yet everybody's used to it, and they don't say anything. For us to have technology, for us to have electricity, we can't put it all underground, so there it is. And to me, this is something similar. It's, it's a sign of technology, but I don't think most people can expect to live and only see trees and flowers and grass. I mean, that's not the way the world is.
Okay, so could you relate that back to this specific application then?
Yeah,
What are you saying?
It's in the middle of the forest, to the extent that they can screen a fence, which can be considered unsightly, then they have control over that small area. But, I mean, to make it so that it can never be seen and as if it doesn't exist, I think is unrealistic.
Can I ask, what's the size of the base of the tower? What's the diameter of it?
The compound or the actual tower
The
itself?
tower itself.
It's a monopole, so it's probably about 4 inches in diameter, tapers to about 18 at the top.
You said 4 inches.
4 feet.
4 feet.
Sorry.
Okay, so
4
it's a
feet, and it
okay.
tapers to 18
Okay,
at
so
the
it's a little
top.
bit bigger than a tree trunk.
Well, big white
Thank you.
pine can be 4 feet across.
Okay, the other thing I would call the board's attention to is, and this is section 1000, where it talks about landscape requirements, area landscape regulations. Section 1000, the land use ordinance, page 10-1, it states, all new commercial development proposed within Rockport shall be subject to the regulations, procedures, and standards specified in the following sections that relate to landscape plan, in addition to those standards pertaining to the particular district in which the development occurs. To achieve these goals, the planning board may waive requirements that it deems to be unnecessary to a specific development project. So this section of the land use ordinance does give the board a little bit of latitude in considering the landscape requirements here on this. Other inputs or discussion on landscaping related to this? John, anything?
Well, one of the public comments, I mean, the point they raised was, we're talking about, what's the footprint that we're talking about here for the leased property? What is
The lease area is 100 by 100, and we build a 50 by 50 compound.
right, so we're talking about 100 square foot space surrounded by acres, that are not part of any kind of plan or anything. So is there anything to talk about there? I don't know. I mean, in some ways, we're saying the landscaping plan is, to the point of the person, who, I think it was Lucy, said, is dependent on the property that this is not on. Those trees exist on property that the cell tower won't be able to control.
Okay, so let me just say that there is also a statement in here in the original application that states that the trees will not be, oh shoot, I gotta find the statement, but it says the trees will not be cut on 25 acres, which I assume is the entire lot.
I don't remember making
I'll find
that
it.
statement in
It says that.
my application.
Yeah, it does say that, I'm sure. I saw it in a couple places, actually. So just give me a minute here, so I can find that.
Yeah, we have no control over that.
I mean, the plan that we were looking at briefly showed an LOD line, limit of disturbance line, so that clearly delineated the area that would be touched versus not. So you could see the areas not touched.
That's correct.
Yeah, I thought I recall seeing something like 2.48 acres if you included the road plus something to that effect out of the total area. John?
That sounds approximately correct.
Okay, I think I remember seeing something like that. To your point, I guess it would be a comparison, comparable to that would be you have 3 parcels. This is a landowner or a homeowner, and someone wants to build a house or a structure on this parcel. They don't have the rights to this parcel, but it's still visible from this parcel. You see what I mean? The space that's not leased to the cell tower,
Yeah.
in those trees, and I think, Lucy, you brought it up, that
No, I
I don't know if that has any impact on
Yeah, I understand, that's a good point. But in that 100 square foot space, what are we requiring in the way of a land? All we've looked at is pictures of space outside that 100 square foot.
Well,
That's all I've seen.
so if you have a 50-foot square within a 100-foot square, that means you've got 50 feet
Right.
setback from the outer perimeter.
So
Where the
we're
fence
assuming,
is.
we're assuming that's all thickly wooded currently.
Okay, but there could be, and it's all deciduous, or mostly deciduous.
So you're talking about tree trunks.
Yeah, but you could put conifers in there,
You could,
and some hemlocks.
but we're not asking for that. We haven't
Well, I'm saying
seen
we
what-
could ask for that.
I know, that's precisely the point, is we haven't really asked, we haven't really seen what the plan is in the space that they control, because the photos won't show it. And I don't think it was anywhere in the plan, was it? Any of these?
It does say here in their application, landscaping, the base of the tower will be screened with existing mature foliage from view by abutting properties, is what it says. So that was their landscape plan, is to leave the existing mature.
Should we have it amend it perhaps to read something that in the event the entire place was clear cut, it would still not, they would have plantings there that would make sure that didn't happen. Because I think right now it's all dependent on the surrounding woods to give them the cover that we're assuming is going to be there.
Well, you have no idea what it's going to look like in winter when all the leaves come off.
Yeah, exactly. And there's that.
Well, I think it would be the responsibility of the applicant, the person who owns the lease, perhaps jointly with the person who owns the property, to maintain anything that's there present or as part of this application.
Right, and that's
So
what
if they
I'm
had a planting
proposing.
plan that showed a ring of arborvitae around the base of the tower, and those got knocked over by a storm, they'd be required to put them back. So no matter what happens, they're required to maintain the screening from the adjacent properties.
A ring of arborvitae would be nice.
The only thing I'd say about that is that deer would eat it.
Well, I'm,
Not if it was inside.
I
Yeah,
guess
not if it
I'm
was
just
inside.
thinking
Right.
more from a conceptual
Right.
standpoint. I'm not an
Right.
Something,
expert on.
maybe something other than that, yeah.
But in lieu of the arborvitae, if we determine that the present foliage that's there now is sufficient, then I would think that maintenance would apply to that as well.
Right, but we don't even know if there is any foliage in that 100 square foot section. As far as I know.
Or
I haven't-
outside it. Or I'm saying, but outside it also, since the
but
area
that's-
outside
that's
is doing
land,
the work.
To Mark's point, that's land they don't control. And so that's like having a parcel of land between the abutter and the,
Developer.
yeah, we're really talking about that 100 square foot section.
Can the property owner be held liable for maintenance of this
Well, they're
Depends
not the applicant.
Whether or not it's inside or outside of the lease agreement.
for the area outside of it?
It's chain link fence.
Yes, sir.
Can you weave green plastic through a chain link fence? Is that
You
screen?
you can put slats in the fence. Yes, sir.
The ordinance does say plants, so.
If I may, Mr. Chairman,
Yes.
the lease area is 100 by 100, so it's 10,000 square feet. The compound that we plan to build is 50 by 50. That's 2,500 square feet, so that's a quarter of the area. It costs money to clear trees, so we're not clearing anything more than what is practical to erect the tower and the compound. So we're leaving 7,500 square feet surrounding the tower base untouched. And as I'm sure Mr. Gashlin will tell us when he was out there with the tarp, it's not exactly standing in a field. There's quite a few trees there.
Well, all I can see is a sort of out of focus overhead photo. I don't know what's there in that square. That's my point.
Well,
I
you
don't
can
know.
tell
There
also
may
from
be
the
no
aerial
trees in that
photograph
square,
that
as
there's
far as
quite a
I
few
know.
trees in there. It's dense.
Okay, I did find one of the notes that I was looking for, and that is, this says existing foliage in close proximity to the development includes approximately 70% coniferous trees, 75 to 85 feet in height on the average, and 30% deciduous trees, 35 to 55 feet in height on the average. Such foliage will be maintained as a buffer to the greatest extent practical. So that's on C1, it says that. And I'm still looking, I know there were a couple of comments in here about maintaining 25 acres of foliage.
Which application, which date, which page? Sorry.
This is called New Site Plan, and this was from July. And it's note 3 on the bottom of C1.
728, okay.
And by the way, I called out that language specifically because in section 8094, that's the standard to view from abutting properties to the maximum extent practical.
It was called new site application, Joe?
New Site Plan,
Yep.
and it's page C1, note 3 on there.
Page C1 of, is that the 20-page document?
Correct.
Yeah.
Up at the top is the second page. It's, this one. You zoom in on the bottom right corner of that map. The note's way down there.
Oh, my God. Okay.
Okay, so where are we ended up here? Are we concerned about the trees being knocked down on the entire property? We're concerned about trying to put some kind of buffer around the fenced-in area. Where's everyone's mind at?
I don't think the intent is to knock down trees on the entire property by any means.
But the concern is that there's nothing that doesn't restrict them from clear cutting it.
I see. Okay, got it.
Yeah, there is nothing that
So,
governs that.
I see.
Joe, this note that you're reading, you're talking note 3, right?
Correct. Yes.
It says existing foliage in close proximity. It doesn't actually say in the 100 square foot.
No, it doesn't.
Okay, I just want to clarify.
Yep. Yeah, I don't think there's that many trees that you would count in the 100 square foot.
Oh, my question is actually to that note on C1, whether the maintaining of trees outside the leased area is something that can be enforced on the property owner.
Well, if this is the agent as listed on the application representing the property owner, and we asked that that be put into the lease, that those trees were not knocked down, I think that would cover it.
Right.
You are the agent representing the property owner, correct?
We represent US Cellular. US Cellular has a lease with the property owner.
Okay, so,
They're only representing inside of the red line.
okay, so then we would ask for that condition to be met on the entire property if we felt that was the right thing, and we would need to get concurrence from the property owner before it was approved, if that's what the board chose.
So what are you asking, sir?
We're not yet, we're just
Okay,
discussing.
thank you.
Thank you.
I was not clear.
Sorry, I'm still looking for that information that I saw in here. There are so many notes in here, it's hard to.
I'm impressed that you found that.
It talks about the seating on, whatever this is, G1. G2 talks about the seating and maintaining the seating in the area. And that was considered originally part of the maintenance plan. Landscaping maintenance plan. All right, I'm not gonna find that now. I'll find it, I'm sure, once we get out of here. But I know there was a reference to 25 acres. I'm sure I saw that, and I saw it in a couple places.
And what's your point about that, Joe?
Well,
25 acres?
it said that the vegetation would be maintained over the 25 acres, is what it said.
That's the entire parcel.
I don't know what 25 acres is, but I would guess it would be the entire parcel.
I think that's on page, I think it's on page 3 where it addresses section 1305.1.
Did you find it?
I think so. It says existing mature vegetation.
There it is. Thank you. There it is. That's it. So we're looking at the original application here, and we're looking at digital page 3 in the digital document. And the response under 1305.1 that Tom found states the existing mature vegetation on the 25-acre undeveloped parcel will be maintained to the maximum extent practical to screen the facility. Accordingly, U.S. Cellular meets the ordinance to soften or screen the appearance of off-street parking areas from the public right-of-way abutting properties and structures. So you did sign up for that. I don't know if you have the authority to sign up for that, representing your landowner, but it does state that in the application.
That doesn't bind the landowner, though. That
No,
just
so
binds-
what we'd have to do is as a contingency of approval is the landowner would need to have that put into the deed. I mean, that's what was put forward here by the agent. So we would ask, which I don't think is an unreasonable thing, the landowner to put that in the deed so that maybe future property owners would have that same restriction.
Conversely, couldn't the applicant produce, in the event of, say, a storm brought down the trees that were doing the screening, couldn't the applicant on their own leased land put screening in? Instead of the landlord having to come in and do it
Sure.
outside the leased area?
Sure.
So it's like one or the other.
Yep. Or
Can I
both.
comment
Or
on,
both.
can I comment on that?
We're good, Bob.
Why don't you come up to the microphone, please?
No, thank you.
Okay, so anyway, we've got a statement in here, whether or not it's binding or not. It does say that their intent was to maintain the entire parcel.
Can I offer a small piece of information?
If you'd like to step up to the podium, please.
It's my understanding that this parcel is taxed as a tree farm, and there are a lot of conifers that were planted years ago. My understanding is that tree farms are harvested eventually.
Mhm.
I just thought you might like to know that.
Thank you. Okay, so let's try to wrap this landscaping thing up. The intent is to be able to maintain, I think, the shielding, screening for a long period of time throughout the useful life of this. We've talked about doing it in a couple ways here. We put screening around the small fenced-in area. We could try to maintain the wooded area that is between this and the abutting properties, or we could do both. It does state in here, the intent was to maintain the entire property as being undeveloped and not knocking the trees down. If we did that, I'd propose we put a condition in there that be entered into the lease, or we could not do that and ask for screening. So where's your head at?
Per this initial application, the lessee does not have the rights to maintain 25 acres of undeveloped parcel.
Right.
Yeah, I think we should just limit it to the 100 square feet and call it good. I think that's what we really are focused on, right?
Okay, so screen the 100 square
Sorry,
feet.
I didn't mean to cut you off.
No, I said what I had to say.
Okay, so you just wanted to make clear that you believe that the leasing agent here has no right to speak to the 25 acres.
That's correct.
That was an incorrect statement. Okay.
Also, I can elaborate on tree growth
Yeah.
category because I happen to be a Maine assessor. And tree growth has to be, for a property to be in tree growth, it has to have a plan by a certified forester. And it does have to include harvesting. There has to be a plan to maintain it as tree growth because it's looked at
Right.
as an asset that
Right.
has to eventually provide value.
I looked at that on my property. We
Right.
said,
Okay, so if we exclude this requirement, that means that that can be clear cut, and that's independent of whether there was a tower there or not. Like you've just described on a timber property, it can be clear cut.
Well, it wouldn't be clear cut if it were.
Well, not clear cut, but harvested, yeah, significantly thinned out, okay. So that would still be allowed. So if you put screening in there, what kind of screening do you want to put in around that small facility?
Arborvitae, hemlocks.
Something,
Inside the fence?
inside the fence?
Inside the leased
Deer are
area.
gonna, deer are gonna eat it.
Well, then you're gonna see the fence. if it's
Outside,
Inside the lease
outside
area.
the fence.
Would it grow kind of through the, no,
Outside the
50 by
fence in
50
the
is the
area.
fence.
50 by 50, correct?
And 100 by 100 is the leased area.
Yeah,
Correct.
so between the edge of the leased area to the fence has to be
Agreed.
screened.
Between the edge of the leased area.
The leased area is
and the-
100 by
okay,
100.
Okay, so outside the fence.
Outside the fence.
Okay,
but
you'd
to
like
the
to see,
edge of the
you'd
leased
like to
area.
see some kind of natural screening there that would be consistent with wildlife, that it wouldn't be all chewed away, and it would be all the way around the perimeter of that fence,
That's what I was gonna ask, on the
or just on the current property butter side where there is a structure.
2,500 feet of plantings at the fence line. Half a mile of plantings at the fence line,
Half a mile?
2,500 feet. Oh, sorry,
No, no,
5,280.
Just to be clear,
no. Really? No.
No, can't be. No, that doesn't add up.
No.
No.
just to be,
200, sorry, no, never mind.
to be clear,
100 feet.
Yeah, yeah, I got
It's
it.
100 square feet, isn't it?
the ordinance does not require that the fence be screened. It requires the base of the tower be screened. So if the planting is within the fence area,
Where does the ordinance
That's
say
okay.
the fence has to be screened?
it doesn't.
I don't know that it does.
It
doesn't
doesn't.
say
I'm
anything
saying
has
it
to be
doesn't.
screened.
Well, it does. It says the base of a new expanded wireless communications facility must be screened with plants from view by abutting
Okay,
properties.
okay, so you're in section whatever,
80,
80. Okay, sorry, go ahead.
809.
Okay,
Favorite section.
okay, so it does say it has to be screened.
It does have to be screened with plants.
Okay,
So that would just be around the pad.
okay.
It doesn't specify whether the fence needs to be inside that screening or outside. So that's a separate matter, and that's really for
That's for them to
determine.
determine. I would think they're probably gonna have an issue putting plants inside, around the base of it, and having them grow inside there is probably.
And get deer.
Yeah, but that's up to them. So it needs to be screened with some type of natural conducive that would survive wildlife. Okay, so everybody okay? Resolved, landscaping, something around the fenced area, that would shield it. That fenced
Inside
area.
the fence area.
What?
What did we figure out? Inside or outside?
Outside,
Doesn't.
around it.
What I'm saying is it doesn't matter. It doesn't matter to
Okay.
the ordinance whether it's inside or outside
Alright,
of a fenced
great.
area.
Works for me.
Okay. Okay. Let's move on.
It also says existing plants and natural landforms shall be preserved to the maximum extent practical. So practicable. So.
Okay, breakdown of surety bond. Anyone have any questions or issues with that? Okay. It looks to me like those are reasonable estimates.
Does that mean, it says surety bond is supposed to be 150%, right, of the decommissioning costs?
Of the
Back up.
46 or 48, then the surety bond's gotta be 75.
It would, right, it would be 46 plus half of 46. So
Okay.
that's 23.
Okay, so it'd be 150% of that cost estimate they provided.
Right,
And
so
that's
like
defined.
69 and change.
Right. Okay. Everybody good with that?
Yes.
Okay. Images, we asked for images for Vinyl Street. And I think the initial concern there in the Vinyl Street thing was just what it was gonna look like after, the entrance was made. And I think some individuals just expressed concern about, piles of rubble or trees or things like that around there. I think that was where that, concern initiated. And since we didn't do a site walk on this, we didn't really have much of an idea what it looked like. So those photos where it's gonna break through, Orion, regarding the final state of that after it's made, that road, is that something that the code enforcement officer would be concerned about and look at? I mean, just making sure that there weren't piles of
Just the
debris and
entrance of it.
rubble and,
Because it's not a public access road. It's
Right.
more of like a logging road.
Right.
So we're not gonna go up it. And even that further, if it's privately owned, we're not gonna go through and regard the maintenance. But back onto the bond portion of it. So in our subdivision ordinance, we have that requirement. It's 125%. In our land use ordinance, we don't have a surety bond.
doesn't
We have-
say anything, it's
We have a
silent.
surety bond for our solar farm ordinance, but what is it in the wireless?
What did you say for the solar?
Doesn't refer to a percentage.
The solar, solar farm has a surety bond.
For
And
what
I'm trying to
percentage?
find, I don't remember.
The surety bond is referenced in 809.3, number 10.
Thank you.
I don't remember the percentage.
And there is no percentage.
No.
It's just the cost of removal.
What's the typical lifetime of a tower such as this?
Can be 100 years.
I know one of the things we talked about in the case of the solar farm surety bond was escalation on it.
I might be getting it mixed up with the solar.
What, the 150%?
150%.
Because $45,000 today and $45,000 in 35 years would be, the decommissioning cost would probably be much different. I think what we did last time is we just left that for the town and the town attorney to resolve and negotiate that surety bond. And I would propose we do the same thing. Rather, we don't know much about them. I would propose we let those people that know more about it work out those final details with the applicant, whether it's 150, 110, or 100. Okay? So, those were all of the items. So we have nothing else to say about that entrance then.
I would just bring back up the ability to have a third party review the.
Those are the last two I was going to come to.
Oh, sorry.
Yes. Agree. Okay, so third-party review of the submission, application submitted to determine whether this could be satisfied with existing facilities. Anybody have a concern that they would want to exercise a third-party option?
Well, actually, I have a question. It's sort of related, sort of not. What are the issues about moving the location of this 100 square foot, parcel? Could you move it to a different part of this property owner's 25 acres?
That would be a substantial change.
Substantial changes.
And we're also at a specific elevation that is necessary for us to provide coverage in the area necessary.
But is the elevation that different if you went to the far side of the lot?
It is. We're on the high point.
Well, how much is the high point versus the rest of the lot? That's my question. Again, I can't judge necessarily from, well, maybe there's a topo in here that I can check out. I guess I'm just asking the question of how complicated, how involved is that, other than, you may have to redraw a few maps and that's.
Well, it does several things. All of our filings with the federal government would have to be redone because we have filed with the FAA and FCC for this specific location. It would also exponentially increase the construction costs. We'd have to build additional roadway and utilities to get to another location on the property.
Well, I'm thinking, if you just, not sure what direction this is, east, I guess, is east the top of these maps? I'm not sure what it is.
It should be a north arrow.
You call up, Ryan, do you have a map you can call up on the screen?
That's Rockland Street.
There's a topo map on page 15.
Page 15, thank you, Tom.
From the July.
Okay, here's one.
So it's not located at the highest point on the
Correct.
hill. It's
Yep.
located at the highest point that you could build it on this property.
Yes, correct.
So if you move that,
We get closer to that property line to the south.
yeah, if you move that to the other property line, then if somebody built on the other property line, they would be closer to the cell tower.
Yeah, but they would be building with the tower already there. You know, they'd already know what the issue is. The thing that's troubling to me
Yep.
is you've got existing property owners who are very concerned. Is there any way to try to meet them halfway on some of this? And how difficult would it be to just move this further away from their particular property?
Let me throw out a crazy idea. You got 3 sectors. You got three antennas covering 120 degrees each. Do you need that sector that faces that house?
Absolutely.
You do?
Oh, yeah.
Okay, I thought you were
Yeah.
trying to cover 17, which was that way, and the house was over here.
We're trying to get 360 degrees of coverage throughout the area.
I thought maybe there was a chance that you wouldn't need that
Nope.
sector back there. Okay, thank you.
Can you call up that topo map again?
It looks like you're at about 430 feet here.
If I may, as you can see, that any movement farther away from the house.
Right, where are we, Ryan? I can't view these maps this way. What document?
The one on the screen here, John, we're looking at.
I know, but
Oh.
good luck trying to see anything from here. So,
There you go, John.
what?
Bigger.
Thank you.
Let me know when you're ready.
Step around.
This one, it's this one.
Okay, click cell tower. To 720. Page.
Thank you.
So any movement away from the southern property line would be a dramatic reduction in elevation, and also, as you can see by those topo lines, they get much closer together. So that means extremely difficult to build on it. So that's not technically feasible. And as I mentioned, all of the documentation that we prepared for the site would have to be changed, which is a dramatic undertaking. It would take 4 to 5 months and hundreds of thousands of dollars.
I guess,
Well, then how much would a separate?
Plus, any reduction in ground elevation would require a taller tower to be able to cover the same footprint.
Would be what?
Would require a taller tower.
I guess just a basic question, if we're going down this kind of route, is do we have the authority to require it to be placed elsewhere on the site?
Why are we seeking for it to be placed elsewhere?
I'm just offering it.
Can I just note that the application you have in front of you is an application for this particular site?
Right, but given, I guess my point is, you know,
We have to approve or disapprove this application. We can ask things that reasonable parties might be willing to do.
I'm asking,
Right.
just like we're asking about whether we would require an independent
Right.
third party do something at the cost of the
Right.
the applicant's cost.
Right. And I think he's basically said that would be I think. don't wanna put words in
substantial
your mouth.
change.
Substantial change, and it doesn't sound like they're willing to do that, is what I think.
And how
I'm hearing.
much does an independent third party study cost?
Okay, so let's come back to my original question, independent third party if we can, and let's talk about that. We talked about that last time. Does anyone feel that we need a third party to be able to review whether the existing towers and facilities in the area would meet these requirements?
Well, I'd be curious to know how much it would cost. What typically those kind of studies cost.
To be honest with you, we haven't done one in probably a decade because the science is the science, it's mature. So I couldn't give you an accurate number.
Who does your studies?
C2 Systems didn't do.
C Squared
Oh, sorry.
out of Auburn.
And they do them for free?
No, they don't.
So what do they charge you when they do?
Approximately $10,000.
Okay, that's
But-
pretty steep.
But you said you haven't done one in 10 years. Did C Square did not do one for this
No,
project?
what I'm saying is
Oh.
the municipality has not asked us to have a third party review our application materials in more than a decade.
I see, thank you.
I was saying it's an established science, and C Squared is a recognized expert by federal courts, state courts, municipalities, all kinds of places all over the country. So,
Just, if I could be heard momentarily on this, the email that you received from your town attorney cited language as to the circumstances that would need to be there for you to request a third party. And it says if there's a technical deficiency in the materials that have already been provided to you. And so we'd submit you'd need to make a finding of some technical deficiency in the information that was provided to you from C Squared.
Okay, so my appraisal of this situation is that when I look at this topo map, the area that we're trying to cover here on Route 17 is almost kind of in a valley. And from one of the other maps where they showed us that the other antennas are currently located, those antennas are on the other side of hills, or I guess you wouldn't call them mountains, but hills from where this valley is.
you're saying the other existing towers, sir.
The other existing towers, right?
You are correct.
And so from looking at this map and the topographic data that they have provided us, I think it would be difficult for them to achieve coverage, line of sight coverage with a signal that radiates from the tower and goes straight out. If there's a mountain in the way, it's not going to go through the mountain. And so to achieve coverage in the area they're trying to achieve it in here, there would need to be something that could reach that valley with a line of sight. So that's my appraisal. You guys need to be convinced and comfortable with that, but I don't know how you do that without a tower in that valley somewhere that's going to have line of sight access to it. And that's what those topographic maps and antenna patterns they've showed us illustrate.
I'm guessing without any expertise on the matter, but that the U.S. Cellular would have located their antennas on towers if they existed at less cost than developing a new tower. Just guessing. I have no clue whether
Probably
that's true or
likely
not.
guess.
I would imagine so.
So I don't believe that it could be met with existing facilities based on the data that's been submitted by the applicant.
I agree.
Okay, Tom?
I don't have the expertise to really give a firm answer to that, but
So this is
I would go with Jeff's thing. I don't think they would build a new tower if they didn't have to.
Okay. Mark?
Based on my understanding of the materials, which is of this technical metrics of the materials, which is very, very limited, I don't see any reason to raise any doubt as to what they've represented in the application.
Okay. John?
Well, I think it's it's kind of hilarious on some level, that we're being expected to find technical flaws
Right.
in order to go get somebody who would know technical things to tell us that's not.
Yeah, you can't do that.
I mean,
Yeah,
this is a
that's not gonna happen.
catch-22. It's ridiculous. So
Do you have concerns?
there's nothing we can do about it. That's my feeling.
Is there any questions
Unless
they
I
can
want-
answer about the
yeah.
data they presented that would help you feel more comfortable?
I only have my own personal experience as a U.S. Cellular customer, which I've disclosed in prior meetings, and going out in this neck of the woods, and I have no problems. And I am watching video, and I am on the phone, and I'm not seeing any dropouts. So my question, when I looked at that map, is that's not my reality. So I'm not exactly sure where the problem is, but I'm not an engineer. I don't do this for a living.
Yeah.
I
You're an
haven't,
N of one.
what's that?
You're an N of one.
N of one.
Sample set.
When you collect data points,
Oh, an N of one.
you're one data point.
Yeah.
And
So
so-
my data point says, that that's not the case. I know where some dead spot, I can tell them pretty much where every other dead spot is in the area, but it's not there on my phone.
And so, I don't spend a lot of time traveling up and down that section of Route 17. All I could say is that from a previous planning board meeting, when I went out there to do a remote video of the first solar farm from right across the street from Mesa's Pond, it didn't work.
Okay.
So
Fair enough.
that's my experience.
I mean,
And you're on US Cellular.
No, I'm on Verizon.
Oh, see, you should have switched to US Cellular. You would have had coverage.
I'm from Mill Street, the Gurney Street. Granted, the vehicles per day is probably 10, but there is no coverage there.
Over on Gurney.
Yeah.
Okay.
Till you get to 17.
And you're US Cellular.
Verizon.
Yeah, well, okay, so that's apples, and that's not even a, so, I don't know what to say. It's like,
But
they're saying it's green, I'm saying it's blue.
difference of
whatever.
carriers shouldn't necessarily matter. If there's no pole there, you got to believe that U.S. Cellular and Verizon are piggybacked on the
They're all the
surrounding
same.
poles.
Okay.
Yep.
Again, I'm not a technician, I'm just a guy who's a customer.
And I thought you said last time you were talking just about voice calls.
Voice, and then I've gone out and since done, I've streamed videos just because I would happen to be going there and said, I'm gonna check this out.
Okay, so the applicant has submitted us data. It was done by not their company, but somebody they contract with. Have this company completely biased the data, that we don't trust it? Is that what I don't know that I believe that. I think I would believe the data that's presented here.
I mean, I did a very topical search of C-squared systems, and I don't see any reason to believe that.
Okay, so it sounds like, can I say are we gonna ask them to do a third-party validation?
I wouldn't.
Okay. All right, so that's one of the ones that the attorney weighed in on, and I think we've come to agreement that we wouldn't ask them to do another third-party analysis of this. Okay, so the next one is the FCC requirements. And I read the paragraph of the limitations that are bestowed upon local municipalities. And we have a conflict in our local ordinance, in that our local ordinance talks generally about safety of facilities. It doesn't specifically talk about RF emissions. There are many safety aspects of commercial facilities. We are limited. This board has no authority to base a decision for granting or not granting this cellular tower based on environmental effects or radio frequency emissions.
If it meets the federal standard.
If it meets the federal standards, right, I agree. Thank you for adding that. So, from the data they've showed us in their response to our request, it showed that they were at 1% of the FCC emission standards, emission threshold. If it was 95%, I'd probably be very concerned. If it was 100%, I'd be extremely concerned. It's at 1%. So as far as uncertainty of the data, I think that 1% is pretty far from the threshold. This board simply has no authority to reject it on that basis.
Agreed.
Yeah. So, unless anyone feels differently, I don't think that we could. This board has the authority to make a decision to reject this application based on RF emissions. Agree? John?
That's what our lawyer says, yeah.
And that's what the FCC ruling says too. Okay, so those are the 6 items. Some were on us, some were on the applicant to resolve. So with that, it sounds like we've come to some agreement here amongst the board, at least on a straw poll basis. We've got some requests that we're going to have in the final approval here, such as screening on the base of this. What I propose we do now is just go back through the land use ordinance one last time. We've looked at this previously and decide whether or not we think it complies with the requirements of our land use ordinance. So first off, this is just our normal flow here of what we typically go through in an application. Section 900 are cellular towers allowed in the 908 zoning district, and I believe that they are. They're allowed now with the latest revisions to the land use ordinance in all rural districts. That was what the voters approved, and that's what the ordinance says today. Agree?
Yeah, agreed.
Okay. So Section 900, I think a lot of the detailed requirements are not in Section 900. They are in Section 800 instead, the wireless section. Does anyone else have any concerns that they want to talk about in Section 900? Let's take a look at that. Take a minute and take a look at that. Again, there's not much in 900 regarding cell towers. I don't think the tables that talk about densities and structure sizes of buildings apply here. Small shelters they've got are well within the limits. I don't think density on the lot, development density is an issue in the tables. I don't know. I'm not sure there's even anything in 900 that refers to cell towers. Is there?
It was just the rural zone, but
Just the rural zone?
Yeah.
That's it. Okay. Would anyone care to put forward a motion that the application submitted, as a finding of fact, the application submitted is consistent with the requirements of Section 900?
So moved.
So moved by Tom. Is there a second?
I'll second that.
Seconded by Mark. Further discussion? Hearing no further discussion, all in favor? Okay, 5-0-0. Okay, let's move on to General Performance Standards, Section 1305. All right, 1305 is talks about soil and erosion. They've got a soil and erosion plan, preserving and enhancing the landscape. We've talked about that, softening screening around the base. We've talked about the trees that are there now, vehicular access, parking circulation, surface water drainage.
There's no lighting, right?
There is a 100-watt bulb they proposed that would be on a timer and would turn off automatically. That's all I saw. Air quality, it's not producing any emissions. water supply. I don't think we're polluting the water here or not drawing significant amounts of public water. Anyone care to put forward a motion that the application, as a finding of fact, the application is submitted is compliant with the requirements of section 1305?
So moved.
So moved by Mark. Is there a second?
I'll second it.
Seconded by Tom. Further discussion on 1305? Hearing none, all in favor that it's compliant with 1305? 500. Okay, let's move on to section 800, and in this case specifically the wireless section. Is it 810?
809.
809, thank you. Okay, 809, wireless facility standards. We did go through this last time. I think it's worth reviewing this again to make sure there are no other concerns. It does in 809.4 talk about the fact that it is permitted in a rural location, recent modification to the ordinance.
I don't recall, did we have a copy of the FCC license?
Yeah, the first,
Okay,
That was in the first submission.
all right.
Height is compliant with the requirements of 8094. Setbacks are important, at least 105% of the tower height from the property line. We looked at that previously. Landscaping we talked about pretty extensively tonight. Base of a new or expanded wireless communications facility must be screened, and so in our condition of approval, we will ask the applicant to make certain that around that fenced-in area that it is screened with plants that are consistent with wildlife. Fencing, it is fenced. Lighting we talked about. We did see a copy of the lease in the original submission from the landowner. And on abandonment, we do have conditions and requirements for a surety bond. And we're gonna let the details of that be resolved by the town and the town attorney.
We need to, all these standard conditions of approval, Joe, do they go with the, follow the application, or do they have to be restated, or?
I think we restate those at the end, is what I propose, as we usually do.
Okay.
I have a question of 8094,
Mhm.
Section 8, lighting.
Mhm.
I remember we had some kind of discussion about the top of the tower, but that, it doesn't require permanent, like a red blinking light or anything?
Yeah, I think
like
last time the applicant responded there was no lighting on top of the tower. It was not required.
FAA.
That is correct.
It wasn't high enough to require.
That's
that.
correct. It would have to be 200 feet or taller.
Okay.
Even at that elevation.
At that exact elevation, yes.
And I think it was more security access lighting that's on the bottom of the 100-watt bulb.
Yep.
Okay, any concerns? Anyone want to point to a section?
I don't see anything.
Okay, as a finding of fact, would anyone put forward a motion that the application is submitted meets the requirements of section 809 wireless that describes wireless telecommunications facility requirements.
So moved.
So moved by Mark. Is there a second? Not a second. Need more time to look at it?
How do we include the comments that we had?
What
this
we
motion.
usually do, Jeff, is at the end, with approval of the final application, is we've included whatever requirements there are that would be accomplished to grant approval. So we would typically, at the end, after we go through each section, we'll have the approval of the overall project, and with that, it'll be approval contingent upon these conditions being met.
Well, that should probably be in the motion then, Joe, that we're talking to right now.
Okay, we could restate it then.
Yeah, you might want to restate it, Mark. Well,
Or
first,
I rescind my motion.
Okay, the current motion is rescinded, a new motion is gonna be placed. I think.
Does it have to be me? All right, help me with the wording here.
Right, and I think
well,
it's 809, it's the
do it, Mark?
landscaping.
Yeah,
part
I
of
don't
it.
mind.
Okay,
I usually mess
so,
these things up.
move that the application satisfies the general standards performance for wireless telecom facilities in section 809, with the following conditions of approval of being applied, that the planting be maintained within the parcel. What am I trying to say? Tom, jump in here. Screening, that's it. Screening be maintained within the parcel, and that all the other standard conditions of approval in 809.5 would apply.
I'll second that motion.
Okay, so motion proposed by John, seconded by Mark. Discussion on that.
You said 809.5?
That's what it
Is
said.
that where you're referencing the bond?
Sorry, I can't hear
Is
you.
that where you're referencing the bond requirement?
No, I'm referencing this, well, the standard conditions of approval are included in section 809.5. And let me just.
Oh, I see what you're saying.
Landscaping is 809.4.
Yeah, landscaping is 809.4, but we're taking the whole 809 section here. So I'm just saying 809.5, 1, those conditions of approval apply, standard conditions of approval. Is that making sense?
Right, I think it was the totality of 809 with the specificity of 809.5.
Yes,
I see what he's saying.
okay. Trying to shorten it up rather than read the whole thing.
Okay.
Okay, it's been moved and seconded, I think, Joe.
Any other discussion? Okay, all in favor? Okay, 500. Sorry, I just lost my thought. So with regard to this landscaping plan, I just want to be clear. There is a requirement in section 1000 for a landscaping plan. There was a landscaping plan of sorts that was submitted. It did refer to trees and types of trees and sizes of trees. It did talk about plantings being grass. So I think what the board is saying here is that in addition to that landscaping plan that was submitted, as high level as it was, we're additionally asking for screening around the base of this tower. Is that a correct interpretation?
Yeah,
So we don't consider the application completely delinquent on the landscaping plan. We don't believe it was sufficient in including that screening.
That's
Just want to be
correct.
clear on that.
Yeah, it was not specific enough.
It wasn't specific enough. So they're a very general plan, but it wasn't specific enough.
But it did meet the 809.3 landscaping requirement number 5.
The initial plan that was submitted.
Yes.
Okay.
It's the wireless ordinance site plan review application 809.3 number 7. Sorry. 6. No, 5. Landscaping plan indicating the proposed placement of the facility on the site, location of existing structures, trees, and other significant site features, type and location of plants proposed to screen the facility, the method of fencing, the color of the structure, and the proposed lighting method.
Okay, so we're saying the only part of that that was not included in the original application was the screening. Right? Okay. All right, just want to be clear on that. Okay. Let's see. So that was section 800. Other areas of section 800 that would apply to this, I don't think there are other areas. I don't think traffic circulation applies, and the rest of 800 is not applicable. So I think that was it. It was 809. Okay, so let's move on to section 1000.
Do we need a finding of fact to say the rest of section 800 is not applicable, or
No,
we don't need to do
I
that?
don't think so.
Okay, good.
Let's move on to section 1000. All right, so section 1000 talks about performance standards. It talks about landscaping in the front. I would propose that the landscaping requirements unique to the cell tower included in 809 would circumvent or supersede these requirements. My experience on the board is that these requirements are much more detailed related to a commercial establishment that is located within sight distance of a road. We talk about, small plantings and deciduous shrubs and ornamental grasses and perennial flowers. I don't know that that applies to something in a rural setting like this.
I mean, the first line says purpose is architectural design parking areas for all commercial properties in the town of Rockport. I mean, and then there's having the section 800 specifically about cell towers. I would agree that it would supersede.
It does say that, and let me just read the last paragraph. To achieve these goals, the planning board may waive requirements that it deems to be unnecessary for a specific development project. And I would propose that 809 covers the requirements for a rural located cell tower, that these requirements would not apply. Agree?
I would be in agreement with that.
Okay, if we agree on that section on landscaping, let's move on to 1003, architectural review standards. I don't think that applies here. This talks about sites and commercial developments with buildings. In general requirements for a building architecture. Other than a few service panels, I don't think there are structures or buildings are proposed here. There are no roofs on these buildings or panels. 1004, they did speak to the parking lot that's intended for the service people. Typically 1 car, as it was stated in the application, on the property. And that's all of 1000. So as a finding of fact, would anyone care to put forward a motion that this application meets the requirements of section 1000 and that the detailed requirements of the area landscape regulations in 1002 are waived in lieu of the landscape requirements in the wireless cell tower section of 809?
So moved.
Okay, moved by Jeff. Is there a second?
Second.
Seconded by Mark. Further discussion on that?
This is which section, Joe?
This is section 1000 we're looking at right now.
Okay, that's also building. Are there no building structures associated with this?
No, sir.
None, just the tower itself.
The tower, and there's some adjacent equipment cabinets, but there are no structures.
Okay.
Other discussion, other concerns?
Comments, I would just read section 1003, number 1, and I would imagine that the wireless, section 800 supersedes number
Right.
1 in
It
1003.
also has language about how it should fit in with the landscape.
Number 3, buildings that do not conform with these standards. Is that what you're talking about?
1003, number 1.
1003 number
Visually
1.
harmonious.
Proposed development should be located in a visual harmonious manner with terrain, vegetation, surrounding parcel structures that shall impede. Okay, so you have concerns about that, or you just calling attention to it?
I'm just calling attention to it, and I think that section 800 about the wireless facility itself would supersede being visually harmonious.
Mhm.
I just wanted to call attention to it.
Yeah, it has a color and materials section 809.4 in the standard section. I think we've covered all of that already.
Okay, so discussion closed. Put it to a vote that it's consistent with the requirements of section 1000. Okay, 500. Okay, and that's detailed performance standards. So last thing to wrap this up is just overall approval of the project, and I think it might be just worth restating what, if any, conditions of approval we had placed on it. And I think there was one.
So to start the discussion, the applicant provided what we had requested in the last meeting, which was views from the adjacent parcel of where the base of the tower will be, showing the tarp as a means of providing where the view of the tower is. The tarp was visible in a very small amount in 2 of the photos. Did we determine that screening was not adequate before we got into the discussion about screening it within the leased area? I think we never actually concluded whether that was adequate or not.
The natural screening?
The natural screening that's already there.
I think that
Based on the hardwood?
we didn't have we didn't have anything visually to refer to know. That was my point. So that's why it became a condition of approval, that they ensure that is the case within that 100. So in other words, you have to stand right outside that 100-foot square and look. And if you can see the base of the tower, you don't have enough screening. That would be my point.
Yeah, to me, I agree with you. I think it's unique in that a wireless tower requires screening around it in the land use ordinance. And given the fact that this land could be harvested for timber, you have no guarantees that natural screening that exists today would provide adequate screening forever. And so I think that's why we came to the conclusion of putting that screening around the base.
So is that in the event of the area being harvested, or is it irrespective of it?
I believe it's irrespective in my mind.
Okay.
If not, I would like to make a condition.
Right, yeah, it's irrespective, yeah.
Yeah. Okay.
Okay. Okay, so let me try to restate the motion I had on the table. Or did I have no, I didn't have a motion on the table.
Motion to
Just
approve.
for the discussion, so number 1 was the blue tarp, 2 is the entrance on vinyl.
Right.
3 was copy of the rights of easements. 4 was the surety bond replacement removal costs, and then the 2 items that the town attorney weighed in on, which were
The FCC.
the FCC, as well as the planning board's ability to require a third party to assess the
Right.
technological merits of a site here, I guess, or the need, demand, whatever you want to call it.
So, thank you for bringing those up. I think we've resolved in our mind those 6 items, based on our discussions this evening. And those items no longer pose an issue with compliance with the ordinance. That's at least in my mind. Okay, so overall approval of the project, as a finding of fact, the board has found that the proposed wireless tower meets the requirements of the land use ordinance and is approved with the condition of providing screening around the base of the installation.
Irrespective of adjacent land and their parcels.
Irrespective, with natural vegetation that survives a wildlife environment.
Well, it doesn't, it's gotta be visual screening. If the wildlife come in and eat it down, they
That's
gotta
not
do,
visual screening.
then they gotta do something
Okay.
about it. So you wanna restate it, Joe?
No, I can't,
All right.
but I'll try.
Condition of approval that visual screening of the base be maintained irrespective of the adjacent land and/or parcels.
Okay, so any other conditions that we came across this evening?
The standard conditions of approval in 809.5.
Right.
And
So we want to include that, the standard conditions of approval.
agreement with the town on surety bond.
And agreement of the town in negotiating the proper value of the surety bond.
That should cover it.
So that's 3 things.
Well, there's a lot of conditions of approval in 809.5, so, yeah, 3, yeah.
Okay. Anything else? Any other discussion? Okay, so that was a motion. Did anyone care to put,
That was a motion?
that was,
Yeah,
that was the
I'll-
wording. Anyone care to put that motion on the table forward?
I'll take that motion.
Okay, so John's putting the motion forward. Is there a second?
I'll second that motion.
Seconded by Mark. Any further discussion on the final approval of this project with those conditions?
And what was the third condition?
The surety,
Surety bond.
8095 and
Landscaping.
screening.
Meeting the conditions 8095, final negotiation of the surety bond with the input from the town attorney and the screening around the base.
Okay.
Instead of town attorney, just say town manager.
Town manager.
It's congruent with the other performance guarantees that we do.
Okay, so the motion is restated, approval of town manager. Approval of the surety bond in discussions, negotiations with town manager.
So moved, if you need a second again.
Okay, so, so moved.
so moved with amended language.
Okay, thank you.
So moved with a second.
Okay, so I got it placed, second. Any further discussion on final approval? Okay, all in favor? 500. Okay,
Thank you for your time.
thank you for coming. Well, we got just a couple more things. Want to take a short break or let's drive on? Hold on.
I'll be in touch.
Okay. We'll talk through minutes. We got 2 sets of minutes to approve. Hopefully we've got the right people here that we could approve those this evening. Orion, we're gonna go through approval of minutes
Yes.
when you get a chance. Let's do July 1st, July 1st in order.
Okay.
July was the initial, okay.
So July, Joe was here, John was here, Mark was here, Tom was here, Jeff was here. Great, everybody. So we got the right attendance. So we can go forward and approve this. Any comments or questions about the document as it's modified? A lot of,
Ryan, have I gone through this one?
Yeah, I believe so.
I don't see any.
I see your comments, John.
You do?
I do.
Yep.
yeah.
Has Tom gone through it?
Is Tom going through
Yes,
it
I see Tom's comments.
definitely gone through it.
Okay,
a couple of times?
okay.
Thanks, Tom.
Is there some place, like, besides having comments, would I know the other members have gone through it in any way?
Let me see what you got.
I know Mark usually puts a note up on top
Yeah.
when he goes
Yes.
through
So,
it.
if
Which I
you
did.
scroll down a little
Yeah,
bit.
I don't think you did on this one. You did on the other one, did you? Huh, why don't I see that? Oh, I don't see it because I opened it in Pages.
Oh, did you say
That's
it?
why.
So if you see
Yeah,
it,
that's why.
you click on that, you can see,
I did, a question came up on the next one that I'll bring up.
so you did that.
Okay, got it.
And for every, so you're all the red.
I knew I saw your note on there when I viewed it in Word.
So
online.
maybe just as a process thing for all of us. So I like what Mark does where he,
Yeah, that was a good.
so sometimes somebody might go through it and not make any comments. If you haven't made any comments, make a note up on top to say, looked at it, looks fine. And I think that'd be helpful.
I tried to do that in the past.
Agreed.
I don't have anything.
Okay. So, no, I hear no comments or no further changes and acceptance of the changes that are proposed.
Well, let me see. Did we get clear on the architect identification? I've got some comments in there.
Yeah, so Amanda Austin, she's from 2A Architects, so I added that in there.
Okay.
And then you had another question.
State Road, Rockport, LEU would not be.
Yeah, about the state road, there was, the board may, is that where I had?
Yeah, the need for right-hand turning lane, and then
I
we
think
just,
we decided that we have no jurisdiction over that that's the state.
The right-hand turning lane?
No, it's not that we didn't have jurisdiction over it, it's, they already had a permit for it. So MDOT's already saying that what's there is sufficient from their standpoint. Our
Oh.
ordinance says that we require a right-hand turn, that jut off.
We
I
waived
think we
it.
used our waiver.
We
to
waived
apply
it.
that.
Yep.
And, because there's only 2 right-hand turn lanes on all of.
Yep.
all
So
commercial
do we
street.
need to reference that we did that we waived it?
Oh,
or-
I thought I did
Did we
see
not
reference
have
to
Yeah,
that.
that's
the
what it
waiver?
says. That's what it says, to waive the requirement of 808.3.
Yeah. Yeah. It's on page 5.
Oh, sorry.
There we go.
Page 5. It's kind of hard for me to figure out what's page what here, so let me see. I don't see a page 5 on my.
Yeah,
document.
the way they have it set up. Just one continuous page. You are,
Oh, you're right.
scroll.
Oh, it's a digital page 5.
go down.
2.
It's, okay, 2.
It's the bottom of 2.
Got it, thank you. Where it says,
Oh,
where it
okay.
says footer there?
Okay. And then this one area was really garbled. I
Wave 803, okay.
the finding, I guess, Mark, that's where,
Oh, did I mess that one up?
seconded by Mr. McClare, that I don't know if this reflects what we actually found as our finding of fact, is complete as referring to section 803.3, we have used section 1306.
Which allows us to waive it.
That's the, 808.3 is the waiver, right?
808.3 is the section that we were waiving. 13.1306 is what enables us to waive it.
I see, okay.
Okay, well, I just think there's some words missing in here, because it's, at least to my eyes, it doesn't,
Well, there's a period that shouldn't be there.
says that section, and we have used section, yeah, okay, to mitigate, maybe that's.
Want to take the
what's-
period after 1306?
Yeah. Who's JL? Is that Jeff?
That's me.
And what about the "we" following section 308 or 808.3? What is that?
We have used,
I guess it's
That
the board.
section is complete.
And just get rid of "we have used," put a period after 808.3, and just say section 1306.
Mitigates.
Mitigates
Yeah.
the requirement. That helps a lot. Whoa, we got multiple people in here now. That's impressive. Okay, now I'm okay with it. I can get rid of my comment, I guess. Okay.
Yeah, that reads better.
Okay, that's all I had. I can get rid of this thread.
Cool. Anyone else? Are we ready for a motion?
Do you want to put a document in here with all the changes accepted or anything, Orion, so?
I'll take care of the cleanup.
Okay, all right, great.
Motion proposed.
I would move, like to move that the Town of Rockport Planning Board meeting minutes from Thursday, July 28th, 2022 are accurate as captured,
As amended.
as amended. Sorry.
Is there a second?
Second.
Second by John. All in favor? 500. Okay, let's move on to August minutes.
I did say I had no comments, but I do have a question. Is Victoria a formal alternate?
Yes.
Yes, okay. I wasn't sure. Okay. Yeah. All right, my question's answered.
Hey, Jeff. What's the name of that guy? That was here for the videography? John Cunningham?
Yeah, so my question was, do we need to plug in somewhere that I was seated as an alternate?
I don't know, is that relevant on top? I think what we've done previously is we've just made a statement below the staff present, not present. Veman and Condon were seated as alternates. I think that's the way I've seen it before.
Yeah, but there's no reference to it in here, is what I.
No, I would suggest we have maybe that statement below, and we don't need to put alternate after your name, I don't think.
Okay. So,
Okay.
Chair Chernoski called the meeting to order at 5:32 and seated.
Right, right, in that sentence. 5:32. And I think right
Before the
after,
quorum, right?
yeah, and seated, establishing a quorum, maybe. I'm not online, so I can't.
Who's
modify.
adding it? You want to add it right here?
I would say 5:32 p.m.
5:32 p.m. and seated Mr. Veman and Ms. Condon. And then maybe comma, establishing a quorum. With a quorum, establishing a quorum. Establishing a quorum. Take out with. There you go. I think that's good. This just lacked a lot of detail, it seemed. I thought we changed words in the sections of the land use ordinance, 803, 917, 13. I thought we changed a lot of the words as they originally stated. It doesn't really cover all that here. It doesn't capture all that. Is that important to capture what all the changes were? Because we didn't just approve them as stated.
Well, yeah, it's not
right.
clear.
You're right.
Yeah, it's not really clear the way the language here is, if these are changes we've made, or these are changes that are.
We made, I think, some pretty significant changes.
Yeah.
And it doesn't, it doesn't capture. I think we ought to.
Yeah, because what we voted on to
Isn't what we were given.
forward on isn't what we,
Right.
In the next one, we did change language.
And I think it's too significant, those changes, to try to capture those here tonight.
All right, let's bounce it.
Yeah, wouldn't you agree, Ryan? I mean, we made some big changes to what was sent to us.
I agree. I'm trying to think of how we would do it. We could just put the board discussed a amendments to an ordinance?
You don't
to
want
the
to state
proposal?
exactly what we did?
Not really, because
No.
there's a lot of language in it.
Yeah, there is.
And that's already approved by the select board to go on the ballot.
Right.
Um,
Okay, so at least recognize the fact that at least which ones we made changes to.
Which ones, and just add the word significant to, you know, make sure it's clear we weren't just fixing a few
Okay.
typos. You know.
I could put something together.
Okay, these aren't going to be that hard to approve. They're not that detailed right now, so I think if we could send that back and get that done,
Yep.
that'd be great.
Can do.
All right, so we'll defer those. Let's see. The other thing I wanted to talk just a little bit about is actually two things. One is solar farm ordinance, and the second is the parking ordinance. And so, Orion, if you could just bring up that PDF that I have up there on the, I established a parking ordinance folder right there in tonight's meeting, tonight's date. And I threw a couple documents, before we open that, I threw a couple documents in there. Last time we talked about, let's look at some surrounding towns and see if we could learn anything from them. And so I want to emphasize here, I am not at all suggesting that we want to make our ordinance look like any surrounding towns, because some of them have good parts and they have bad parts. But there are things to learn either to do or not to do from surrounding towns. So I've got Camden's ordinance in there. I've got our parking ordinance there, and I've got the memo. Why don't you just open the memo just for 1 second? So this is why we're doing it, is Mr. Orion Thomas suggested that the planning board look at primarily parking requirements, Schedule A, which defines the streets around the entire town where parking is permitted and not permitted. And the reason he suggested, I think, that we look at that is because it goes hand in hand with land use, especially in commercial areas and residential areas. The parking ought to be consistent with what the land use is. So that's why we're doing it, is because of this request. Okay, so now let's open the other PDF quickly. And I'm not going to go through every page of this, but I just want to summarize what we're looking at here. So review and update of the parking ordinance. Next page. There's the letter. That's why we're doing it. Next page. Schedule. This is the rough schedule I've laid out. We kind of introduced this at the last meeting. I asked people to take a look at. Are there better ordinances around? Please read through ours. This is a September meeting. We're having our initial discussion here. We're talking about a plan of action and a schedule for this. In October, I'd like to talk about proposed modifications. So please come with proposed mods in hand of how you think we ought to do it. November, I'd like to review a final draft within this committee. And in December, I'd like to finalize that proposed changes and then send it on to ORC. And then from ORC, it would, of course, go to the select board. Next page.
Actually, it'll go to ORC, back to you, and then the select board.
Okay, yeah, that's probably true. Yeah, once it. Okay, Rockport reporting. Just the key sections of our ordinance that was last amended in 1997. Okay, so these are all the articles that are included in there. You got definitions, required obedience, which is really a lot of traffic regulations that the police department takes care of. Stopping, standing, and parking. They talk about you can't stop on a pedestrian crosswalk and things like that. I don't care about that, but they do talk in some sections of Article 3 about like Marine Park and other areas where you can and cannot park. So that's why I think it's worth looking at that. Operation of vehicles, police department talks about regulations, pedestrians' rights and duties, again, police department. And then down in miscellaneous is where Schedule A is included. And what Schedule A is a list by street of where you could park on a street. And in some cases, it references businesses that are no longer in existence. So really, Schedule A is the meat of what we're going to look at in Article 6. Stopping, standing, parking in Article 3, it talks about where spaces are prohibited. It does talk a little bit about time limits. So I think we want to propose modifications here, and I think we want to get the Police Chief, Randy Gagne, to agree with what we do in Section 3. I don't think we're going to do that on our own, and probably as well as the rest of it, too. Next page. Miscellaneous. Here we want to look primarily at Schedule A. It talks about specific streets and zoning or parking requirements. And I think we want to look at how it relates to the zones in which it relates and speaks. Next page. There's section 300, just a couple of pieces out of it. You know, it talks about signs in certain streets, talks about limitations in certain areas. Next page. You can look at this in detail on your own. Police chief, town manager can do curb markings. No overnight parking anywhere in the library or Rockport Marine Park is what it says, and Walker Park. So again, I think we just want to consider that. Are there other areas to modify? Do we leave it like that? Next page. That's the rest. This is actually Schedule A. So this is how we do it in Schedule A. Is we talk about it first in general. Parking is allowed on any street adjacent to town hall. Blah, blah, blah. Next page. Winter parking ban. And here's where it gets into like item F. Parking time limit on a portion of Main Street from the end of Pascal Bridge to the intersection of Central. It talks about from the Penobscot Bay Ice Company building along Central Street to a portion of Union Street, ending at Church Street, it's 2 hours. So we want to look at the way it's defined there as well as whether or not the limits are reasonable. And we might look at other limits within the 5 villages within the town also and see if those are reasonable. Next page. Okay, surrounding towns, really primarily Camden. And so again, I emphasize we're looking at good ideas and bad ideas here. Camden, and I'm not being critical, but Camden is much different than Rockport in that they're incredibly specific and detailed in how they define parking. I'm not suggesting we need all of these categories, but it's something to look at as a reference. So they talk about tour buses and they talk about special permits. They talk about shuffling, the fact that it's illegal to shuffle your car after 2 hours. I mean, we're not going to get into that level of detail. Yeah, right. Okay, so we're going to flip through. Go ahead.
Looks like they go street by street.
So they go actually no parking street by street, and they have like alphabetically many streets listed. Next page. Parking prohibited during certain hours on certain streets. Next page. Stopping, standing prohibited during certain hours on certain streets. Next page. 24-hour parking limit for parking lots and streets. Parking time limited on certain streets. And then 2-hour parking on these streets. Next page. Parking limited on certain streets. Restricted parking. And this is references that a vehicle can park specific hours on certain streets. And here they've got ranges of time, but not limiting how long you can park there. Next page. Car parking on certain streets. Car parking only. Only cars could park there. Other vehicles can't. Next page. Permit parking for fishermen and windjammers. I mean, that might be reasonable. I don't know if you need to think about that down at the harbor to assure that fishermen have a place to park. Today we've got it marked with signs. I don't know that we need permits. Next page. Parking of tour buses. I'll just say that today is a challenge with tour bus parking in Marine Park, especially when we get several of them down there. Next page. Violation of shuffling. Okay, that's really an enforcement issue. And is there a next page?
Penalties.
There is, penalties. I don't think that we do have penalties, I guess, in our ordinance. And again, that's probably above our pay grade here at the planning board to establish that. So I didn't intend to go through the detail of this. I just wanted to give you a flavor of what they got. They got a lot of categories in there. I don't know that we need that many categories. Some of those could probably be combined together. Others we don't need.
The question I would have is, do we have any way of just sort of anecdotally checking, is the ordinance they have a problem for the people that live there? I mean, are there a lot of complaints about the ordinance? I mean, maybe it's a good ordinance.
We can ask that. I don't know that we have that many categories, though, like they do.
No, but I'm just saying,
right.
I wouldn't just rule it out of hand, some of the things they have, because it feels, maybe it works.
Could you touch base with your planning director counterpart over there and maybe just ask that question?
Good, but also police chief.
And Randy, yeah, both.
He's
yeah.
all of them.
Could you
Same
do that?
chief.
Okay, thank you.
Probably be easier on the chief to have the same, roughly the same ordinances.
Should we share a
How
parking
much
meter
revenue
people?
does
The
Camden
meter
generate
clerks?
from their
Yeah.
parking?
We can shuffle from one town to the other.
Well, I don't know if anybody's seen it, but they've got the metered parking now down by the harbor in Camden.
It's working.
But I'm just talking about where you chalk people.
I hear you, I hear you. But I'm saying in addition to that, they're looking at metered parking now as a revenue source. in
In
Camden.
the park,
Yeah.
the public lot down by the harbor?
Yes.
Oh, okay.
I think it's on a trial basis, as I understand it.
It's yeah, but it's,
Like the center pay, put a ticket in your window?
Little kiosks that you pay with a
Yeah.
credit card or an app.
Ticket.
Or an app, yeah, yeah.
Yeah, it's like Hampton
people are
Beach.
using it.
I didn't see it.
Okay, so could you please think about that a little bit? Look at the Rockport ordinance. Think about the zoning districts we have in town. Are these reasonable for what we've got? And I guess next time I'd really like to talk about the structure. What categories do we have? And then also talk about areas and whether we need to have like specific rules for specific areas in the 5 villages or rural town or what have you.
Well, I'm not trying to jump ahead here other than, I think a lot of it has to do with
No,
the
you're
width
good.
of
That one's
the
good.
road,
I thought about that too, yeah.
you know, and so maybe we may need to think about that, because I know
Right.
that's a problem on my street.
Right.
If there's a car parked on this side and this side, nobody can get through. So,
Okay, so that's parking ordinance. It's one of the planning functions of the planning board that we're actually looking forward here, trying to establish things to be consistent with the zoning.
Yeah. I think on, oh, never mind.
Okay, solar farms. Well, let me give a little history for people that are new on the board. Probably 3 years ago, we approved our first solar farm. When we approved the first solar farm, the only thing we had in the land use ordinance was one paragraph that defined utility buildings that was intended for like electrical, gas, or whatever utility buildings. Did not at all address any details of a solar farm. So after the second solar farm came in, the planning board proposed to ORC that we establish a solar farm section of ordinance that resided somewhere, either in a separate ordinance or residing in the land use ordinance. So they did that, and when they did that, I feel like if you look at the solar ordinance, which is a separate standalone ordinance, there's this much that talks about surety bonds and decommissioning the sites, and this much that talks about anything that makes sure that solar farms blend in with the community. I'd like to make the what do we want them and how do they fit in the community part to be a little bit more detailed to make it reasonable from a community planning standpoint. And let me just throw out a couple things for your consideration. Would we want all the solar farms to be maybe concentrated within a single area? Would we want them to be spread out across the community and not concentrated in a single area? Because right now, it just so happens the 2 solar farms we have are probably within a mile of each other on hillsides. And so when you go up to places like Beach Hill and you look across, do you want to see all solar farms? Maybe you do, or maybe you don't. Glint and Glare is one of them. If you're driving down 17, do you care about which direction they're facing? The glint and glare, the noise for abutters. If there are inverters in there and they got that whining sound that inverters tend to make, is noise something that we want to be concerned about? Shielding solar farms from abutters. I don't think there's anything in there today. Just like we looked at the cell tower, wireless cell tower, I don't think there's anything in there that speaks to shielding from abutters, and that actually turned out to be an issue on one of the 2 solar farms after the fact. So those kind of things. Again, please think about those, and now I'll turn it over to Mark, who's been looking at this for a while.
In fits and spurts. I'm essentially using the same strategy that Joe did, pulling from some other municipalities. We love it, we hate it. What can we insert? And I'll have that prepared and distributed. Can I distribute it prior to the October meeting, or it has to be at?
No, you can distribute it, just no discussion.
Got it, okay. Distribute it to read.
Right.
Okay.
You can distribute it. If somebody finds an ordinance they like, post it on the SharePoint. That's fine. Just don't discuss it.
Understood. Okay, I'll do that.
Okay.
I call it a week before the October meeting.
Okay,
Then we
that'd be
discuss
great. And then October meeting, we'll probably take our first cut through it, talk about it, and hopefully maybe finalize it by December, so we get it to ORC.
So,
Is-
yeah, I just don't know if this is a typo or not in the existing ordinance. It's quite significant.
Existing solar ordinance?
Yeah.
Yeah.
I don't know if anybody else picked it up. I feel good if Tom missed it. It's in 8C.
What does it say?
There's a word without that I think should be within.
Can you read the whole sentence, please?
It's a long one, but
Oh.
it says, absent a notice or proposed date of decommissioning or written notice, blah, 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 a ground-mounted solar energy system shall be considered abandoned when it fails to generate electricity for more than 1 year without having first obtained the written consent of the code enforcement officer. Should that be within?
So that means the code enforcement officer didn't say you could stop, and they've kind of abandoned that, is what I would get from that.
Oh, they're saying without having first obtained the written consent of to stop.
Right. So it sounds like they abandon it, is what that sounds like.
Okay, maybe that's where,
If it's more than a year,
I think wireless said the
So
same
they
thing,
might-
more than a year, it's considered abandoned.
Yeah.
well, I get that but it's just that one last without, that kind of like, decommissioning a written notice, absent a notice or proposed date, considered abandoned.
Okay, so maybe we can read through that. That's maybe one of the areas that needs to be changed.
So it must be saying to have permission to not operate it
To not operate it
from the code enforcement officer.
beyond a
Apparently,
year.
yeah,
Okay, I reread that thing about 5-6 times and I couldn't.
It is tricky.
okay.
Is the goal for this ordinance, which is standalone, to be in the land use ordinance?
Orion? I was surprised it was not in the land use ordinance. It was
Yeah.
my understanding it was
I'm
gonna
not
be
sure
inside of
why.
it when we approved it.
I think it was a time crunch, and I think they probably made the decision to keep it separate, because I don't know why.
So it's a freestanding ordinance, all its own?
Freestanding ordinance.
Yeah, I looked for it in the land
Find them
use ordinance, and I
electronic.
thought I had the wrong copy, because I couldn't find
I
it.
think it needs to be buried in it.
I think it was put into place after the first farm was constructed, but before the second one perhaps came to review.
Maybe,
Yes.
maybe.
The Blue Wave Solar had to comply, but the previous
they?
one,
Yeah.
I think so.
Yeah, the first one is the whole reason why it sparked it. It's
Because
like,
we've
oh,
got
you wanna
wind
do
energy.
solar?
I didn't think we made it in time for the second one.
Oh,
Maybe we did.
maybe not.
I don't know.
Maybe not, but the first one is what sparked the reason for
Right,
having
exactly.
it.
Yeah, exactly.
But no, the second one does, because the second one has the surety bond. I don't think the first one has the, I think they did a surety bond.
Yeah, they do. Yeah, they do.
think
We
they
asked for it
did
for
do
both, we asked both of
Okay.
them, I think.
I think they just went with it, but there wasn't like a requirement. So that's good.
Okay.
Jeff, you had a question?
I'd like to have it in there.
Yeah.
In
no,
the land
I
use
wanna-
ordinance? It seems like it belongs there. You got
Yeah.
wind farms
The
in
wind
there.
there.
Yeah, wind energy.
Yeah, you have wind, you have the cell sites, it'll fit right in with its own.
So maybe we just wrap that into the changes proposed, incorporating it in the land use ordinance also.
Make it 8:15.
Yeah. Okay, that's all I had for other business. Anybody have anything else to bring up? If not,
No.
we can adjourn if anybody wants to.
Motion to adjourn.
All in favor?
Seconded.
Okay, 500, and the meeting is adjourned at 8:06 PM.
6.